Hello students, today let us look at a focused insurance policy, that is Motor Vehicle Insurance Policies and Motor Vehicle Act 1988. The objectives of the lesson are to provide inputs to the students about the concept and the law relating to motor vehicle insurance, explain various types of insurance policies issued to cover the risks arising out of use of motor vehicles, make the students understand the liability of insurer and owner of the vehicle insured, introduction to the process of filing and settlement of the claims. Introduction to the motor vehicle insurance business. The origin and concept of motor vehicle insurance is of recent times, and the first policy covering third-party risks was issued in UK in the year 1895. Later, the policy covering damages suffered due to the accident by the motor vehicle was issued in the year 1899. The first enactment relating to motor vehicles in India was the Indian Motor Vehicles Act 1914, which was subsequently replaced by the Motor Vehicles Act 1939. A new comprehensive act, the Motor Vehicle Act 1988, was enacted on the recommendation of a working group appointed at behest of the Law Commission of India with an objective to consolidate the existing law and standardization of claim processes and other systems relating to the use of vehicles. Chapter 10 and 11 of the Motor Vehicles Act 1988 deals with the motor vehicles insurance contracts. The motor vehicle insurance business forms a major part of the insurance business in India. Section 2, subsection 28 of the Motor Vehicles Act 1988 defines the motor vehicle to include any mechanically propelled vehicle adopted for use upon roads, whether the power of propulsion, that is transmitted thereto, from an external or internal source, and includes a chassis to which a body has not been attached and a trailer, but does not include a vehicle running upon a fixed rails or a vehicle of a special type adapted for use only in factory or in any other enclosed premises, or a vehicle having less than 4 wheels fitted with engine capacity or not exceeding 25 cubic centimeters. Section 146, subsection 1 of the Motor Vehicles Act 1988 imposes duty upon every owner and the user of the motor vehicle to purchase the insurance policy that no person shall use except as a passenger or cause or allow any other person to use a motor vehicle in public place unless there is a valid policy in relation to the use of that vehicle by that person or that other person, as the case may be, a policy of insurance complying with the requirements of the chapter. Thus, it is a presumption that the vehicles operating in a public place possess a valid insurance policy to cover the liability of the owner towards the third parties and their property if damaged due to the use of such motor vehicle. It is the responsibility of the owner and the user of the vehicle to have a valid insurance policy at every point of time during the use in public places. The insurance policies to cover the liabilities of the owners of the vehicle are to be issued by insurer who is authorized under the provisions of Section 3 of the Insurance Act 1938. According to Section 147 of the Act, motor vehicle insurance policy protects the owner of the vehicles against any liability which is created on them in respect of the death of or bodily injury to any person, including owner of the goods or his authorized representative carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place, and against the death of or bodily injury to any passenger of a public service vehicle caused by or arising out of the use of the vehicle in public place. Thus, the liability under the motor vehicle insurance will be the liability for damage of property, liability for personal accidents, liability without fault, liability to third party, and liability to general public due to the accident caused by the use of the motor vehicles. Motor insurance policy. Section 145 subsection D of the Act defines the motor vehicle insurance policy as a certificate of insurance as defined in section 145B of the Motor Vehicle Act 1988. Section 145 subsection B of the Act defines the certificate of insurance as a certificate issued by an authorized insurer in pursuance of the provisions of section 147(3) and includes the cover note. Some of the important elements of the motor vehicle insurance policies are: policy should be in a prescribed form, policy should contain prescribed information and the conditions of subject matter of insurance. The cover note is valid for a specific period and the insurer has to issue a regular policy within a period. If the insurer fails to issue a policy, the insurer has to inform the Register of Vehicles about the fact of not issuing of regular policy. Motor vehicle insurance contract. The motor vehicle insurance contracts are contracts of indemnity. The insurance companies protect and cover the liability of the owners of the vehicles to the insured. The right of the third party is only on extension of the rights of the insured and he is given protection under the Act. The general principle of insurance contracts such as principle of indemnity, insurable interest, good faith, proximity cause, subrogation and contribution are applicable to the motor vehicle insurance contracts. Liability under the motor vehicle insurance policies. Liability of the insured and insurer can be liability towards the third party risks or third party liability, liability towards the hit and run accident cases, liability under comprehensive insurance policy, no fault liability, third party liability. Section 146 of the Act requires that every owner of the vehicle should compulsorily purchase insurance policy against third party risks. It is presumed that every vehicle has a valid insurance policy coverage if it is operating in the public places. The third party who suffers loss or damage because of the use of the vehicle derives a right from the policy and may claim the compensation from the owner and the insurer who issued the policy. The insurer and the owner are jointly and severally liable to the third party. The insurer cannot avoid the liability to the third party on plea of breach of condition by the owner of the vehicle. The insurer has to pay the compensation first to the third party and then subrogate from the owner. The courts in Weddell versus Road Transport and General Insurance Company stated that though the concept of insurance coverage for third parties against the basic requirement of the insurable interest, it is enforced as an extension of the primary purpose of policy, which is to cover risks to the and in conjunction with a particular core of assured described in the schedule. The liability indemnifying the owner of the vehicle arises only in accordance with the terms and conditions of the policy issued by the insurer. The liability of the insurer runs parallel with the liability of the owner of the vehicle. A breach of statutory duty to insure against the third party risk is wrongful act giving rise to a claim for damages for breach of duty by a third party who is injured through the use of a motor vehicle. The liability of the insurer towards the third party exists only when the policy is valid and the terms of the policy are complied accordingly. One of the important conditions is that the vehicle has to be driven by a person having a valid driving license and issued by a competent authority. And at the time of the accident, policy should be in operation. The third party may claim compensation towards the loss of property, death of a person, and permanent disability of a claimant. The negligence of the third party do not absorb the payment of compensation. The statutory third party insurance do not cover injuries suffered by the occupants of the vehicle who are not carried for hire or reward, and the insurer cannot be held liable under the Act. But that does not prevent the insurer from entering into a contract of insurance covering a risk wider than the minimum requirement of the statute, whereby the risk to gratuitous passengers could also be covered. Liability for damage of property. The insurer has the liability for the damage of motor vehicle insured, provided the policy has the comprehensive cover of the damage. The property in this context is vehicle, and the damage caused to it either by act of the owner or third party or otherwise is to be compensated. This damage of the property may be because of the fire, explosion, self-ignition or lightning, burglary, right and strike, flood, typhoon, cyclone, terrorist activity, transit by road, rail, inland waterway, lift, elevator or air and landslide, and does not include the wear and tear, depreciation, mechanical or electrical breakdowns, failures or breakages, loss where the vehicle is driven under the influence of intoxicating liquor or drugs, and damage caused by overloading or strain of the vehicle. The repairs to the vehicles are to be carried with the consent of the insurer. Authorization is not required for the expenses below ₹500, and in other cases the insured should submit detailed estimates of the cost of the repairs and replacement and should acquire the authorization. In the case of the third party's property damage, it is covered under discussion of liability of the insurer to third party. Liability for personal accidents. The contract of motor vehicle insurance can be extended to safeguard the interests of the insured on additional consideration. He is indemnified by the insurer against the damage or injury caused or received by him while driving a motor vehicle of his own or of third party vehicle with his person. It also indemnifies the driver of the vehicle for the damages or insured suffered while driving the owner's vehicle or any other vehicle with the permission of the owner. The liability also covers the third party who is driving the vehicle of the insured. The risk coverage can be extended to the relatives and friends, including wife and children, at an extra payment of premium. The insurance company is also liable to pay to the insured for the permanent disablement caused to him on happening of accident during the currency of the policy. Comprehensive insurance policy and liability. The insurance company which issues a comprehensive insurance policy covers the liability of the owners to the bodily injury and or death of the third party and property damage, and the personal accident cover for the owner, driver for a specified sum insured. It also covers the liability towards the occupants of the vehicle, provided they are permitted by the owner. The premium payable for the comprehensive insurance policies will be more than that is paid to cover the third party liabilities or the mandatory insurance, as it covers more risks than that are defined by the mandatory third party insurances. In the case Sohanlal versus Bal Swaroop Bal Bhatnagar in 1987, ACJ 113 Rajasthan, it is stated that the quantum of premium depends upon the risks covered and extensions made to the policy. As such, the liability of the insurance companies increases with the increased premium. The comprehensive insurance does not include the unlimited liability of by itself. A New India Assurance Company Limited versus Srimati Shanti Bai comprehensive insurance policy only entitled the owner to claim reimbursement of the entire amount of loss or damage suffered up to the estimated value of the vehicle. The calculation of the compensation payable to the dependents of the person on the death or to the victim on his permanent disability depends upon various factors such as age of the person, earnings and earning capacity of the individual. The compensation also depends upon the extent of additional coverage such as pillion rider, cost of electronic fittings and accessories, etc. Liability without fault. The concept of no fault liability is introduced in the Motor Vehicle Act 1988. It is certainly a deviation from the original ambit of the law. The claimant is required to prove that the accident and the involvement of the vehicle in the accident. The doctrine of no fault liability explains that there is no need to prove the negligence of the driver of the vehicle which caused the accident to claim the compensation. This right to claim the compensation is in addition to the right of claim under any other existing laws. The compensation payable on the death of a victim is rupees 50,000, on the permanent disablement is rupees 25,000. Hit and run motor accidents. Section 161 1B of the Motor Vehicles Act 1988 defines the hit and run motor accident as an accident arising out of the use of motor vehicle or motor vehicles, the identity whereof cannot be ascertained in spite of reasonable efforts for the purpose. If the vehicle is identified at the time of the accident, the claim is not considered as hit and run accident as defined under the section 161. The claim is to be filed as a third party claim under section 146 of the Act. The essential elements for claiming the compensation or damages suffered during the hit and run accidents are: the victim should suffer the damages or injuries resulting from an accident arising out of the use of motor vehicle, and the evidence are not available to identify the vehicles which caused the accident even after reasonable efforts are made. The Act empowers the central government to announce the scheme by notification published in the official gazette. The scheme announced may contain the method of filing claim forms, name and address of the authorities to whom the claim is supposed to be made, the procedure and the process of passing orders of the compensation payable for the victims of hit and run cases, in respect of death of any person resulting from a hit and run motor accident, a fixed sum of rupees 25,000, in respect of grievous hurt to any person resulting from a hit and run motor accident, a fixed sum of 12,500 rupees. The scheme is administered by the General Insurance Corporation of India, and appointment of authorities and delegation of powers are made with the consent of the central government. Claim settlements and tribunals. Section 165 to 176 of the Motor Vehicles Act 1988 deals with the procedures for settlement of claims, the modus operandi of the claims payments, and the jurisdictions of the tribunals and courts in the payment of the compensation. Procedure for reporting and filing claims. The important factors and procedure to be considered for reporting the accident and filing of the claims are: either the victim or the people at the incident should immediately report to the police and the insurance company about the happening of an event, that is accident. If the accident is caused because of any other vehicle, the particulars of that vehicle are to be noted and intimated to the insurer and the police. The situation at the place of accident is to be taken, and note on the accident describing The details of the accident has to be prepared. The details of witnesses and their identification and addresses should be noted down and supplied to the investigating officer or the insurance company. The photographs or the videotape of the place of the accident are to be recorded. With the consent of the insurer, the vehicle may be shifted to the mechanic or repair shed to estimate the damage or expenditure required to repair the vehicle. Care should be taken to protect the property and mitigate the loss. The claim form has to be filled with the help of any expert and should provide all the information required thereunder. The copies of driving license and registration certificates should be attached to the claims in case of accident. A copy of the first information report of the police has to be obtained and attached to the claim form. When the claim form is filed along with the original policy, an acknowledgement may be given along with the claim number. The insurance company appoints the surveyor to assess the damage to the vehicle. The insured is under a duty to cooperate with the insurance surveyor for estimating the loss. The insured should undertake any repair of the vehicle without the consent of the insurance company to do so if the cost of the repairs is beyond ₹500. Based upon the survey report and the documents attached, the claim form, the insurance company takes decision and pays the compensation. If the compensation amount is not acceptable, he may prefer an appeal to the Motor Accident Claims Tribunal, that is MACT, within the prescribed period. Estimation for repairs and invoice for repairs had to be enclosed along with the claim forms. Constitution of the Tribunal. The state government, by notification in official gazette, constitutes one or more tribunals by defining the area of operation and members of that tribunal to adjudicate upon claims in respect of accidents involving the death or bodily injury to persons or damage to the property arising out of the use of motor vehicles. The number of members of the tribunal is to be decided by the state government on the requirement of pending cases. Each member should be qualified to be a judge of high court or district court. If the tribunal contains more than one member, then one of the members will act as the chairman of the tribunal. Application for compensation. Section 166 of the Act. A person who has suffered damages of his own person or property or bodily injures the legal heirs of the person in case of person expired due to accident or injuries caused to him due to the accident, the agent of the person who has suffered the loss of property or the legal heirs of the deceased persons had to make an application to the insurance company and the owner for a payment of compensation. On refusal to pay the compensation by the insured or the insurer, or not satisfied with the amount agreed to pay, may apply to the tribunal having the jurisdiction in a prescribed form along with the required documents within 6 months from the date of occurrence of the accident. Under special circumstances, the tribunal may permit for filing applications even after 6 months, but not later than 12 months. The report made by a police office can be treated as an application for the settlement of claims. The tribunal, after receiving the application for the settlement of claims and verifying the facts and figures of the case, issues a notice to the insurer and parties. The tribunal may take advice or take assistance of one or more professional persons having specialized knowledge in the case in arriving at the award of compensation or decision making. The tribunal may award interest on the amount payable as compensation, if necessarily, depending upon the delay, the payment or extension of the litigation for a longer period. The claims tribunal will have powers on par with the civil court for all purposes of settlement of claims under the Act. The person aggrieved by the decision of the tribunal may prefer appeal to the High Court within 90 days from the date of award. The appeal will not be considered unless the minimum amount of award is deposited in the court. The civil courts at places where the tribunals are constituted are barred to undertake the trial of cases of such nature that attacks the Motor Vehicle Act provisions, and no High Court is having original jurisdiction to deal with the cases other than appeals jurisdiction. Award to minor. The award of any compensation to the minor should be in form of long-term fixed deposits maturing on the date of attaining the majority. The guardians or next friends of the minor can withdraw the money for the expenses incurred. Sale and transfer of vehicles. On sale of the vehicle, the original owner of the vehicle should inform the insurance company immediately about the transaction of sale and transfer, and the insurance company should send the modifications within 15 days of receiving the information. If the information is not received within that period, it can be assumed that the transfer of the insurance policy is affected. If a vehicle is transferred, unless there is an agreement between the insurance company, transferee and transferor, and the transfer is affected, the transfer is not entitled to the benefits of the insurance policy. The physical transfer of vehicle, unless the registration is changed in the name of the transferee, will not relieve the real owner from the liability. Change of registration of the vehicle to another person is not a precedent condition for the transfer of the vehicle. If the owner of the vehicle transfers it physically, the insurance policy ceases to exist. Also, the third-party liability of the insurance company ceases with the transfer of the vehicle by the insured. So far, we discussed about various provisions of Motor Vehicle Act in relation to the insurances and claim settlements of the vehicle insurance policies, either third-party damages or under comprehensive insurance policies. It will give a broad view of the motor vehicle insurances business in India.